Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to another episode of the DWI Guy podcast. Today, we have one of the young guns of DWI defense, James Davis II, on the podcast. James has got such incredible material on his website. I'd really encourage anybody that is listening to this podcast, just right off the bat, if you take nothing else away than this website reference, then you have gained a bunch of information. The website of Davis and Davis, they have incredible materials. I have frequently stolen materials out of, I think it's your dad's handbook, the DWI trial notebook. Incredible resource that's on the website. James, who's on the call with us today, has incredible resources, papers that he has prepared. So go to davislawfirmnc.com, and under each attorney's profile page, you'll see some just incredible documents in terms of research papers that have been done. You guys are like a firm of teachers. So really a impressive website. James has done a number of recent CLEs, has really been about educating the defense bar, helping us all to up our game. So James, it is a real honor to have you on the podcast today.
Appreciate it, Jake. Thanks so much. And first of all, I'd say it's not stolen if we're giving it to you.
That's
so,
right.
Yeah.
Yes. No, we like the idea of stealing stuff though. So if you feel better about stealing it, then definitely go steal. So no, I have a couple of good family stories. One thing, the first time I ever met your dad was at a CLE, I think down in Myrtle Beach. And it was your aunt, Jennifer Hammond, that introduced me to him. Jennifer and I had gone to law school together in the same class, but your dad was teaching a CLE. And one of the main things that he talked about was being a teacher to the jury and basically presenting your case as a teacher to the jury. And it is so easy to see how he does that because of the way that he presents information. Just the way that he speaks and talks, and everything is so logically ordered. But it's just so funny because the first time that I had the opportunity to watch one of your CLEs was you did a CLE with the North Carolina Advocates for Justice on jury selection. And while watching that podcast, literally the way that you talk, present information, so organized, the slides, I was like, man, did James Davis find the fountain of youth? Like what? Like this is literally like, what happened? Like I remember him being like, much older. Like what's going on? So it's just so funny because you guys have such a similar cadence, but also just the way that you present information and talk. It's really cool.
Well, I appreciate it. I definitely learn from the best. I mean, and I'm absolutely biased, but I think you can take it outside of that. I think my dad is one of only 5 attorneys in the state that have 3 board certifications. He's board certified specialist in federal criminal law, state criminal law, and he just passed for family law. So really proud of him. My aunt, who I also work with, she's a board certified specialist in family law. And you can imagine how how fun our family holidays are, right? Debating the law, educating each other.
Yeah, I imagine the office as being more like kind of a professor's lounge than like that when I think of you guys like having conversations. I've literally thought about this in the past because your aunt in particular, first semester of law school, we were doing like lawyering process, and I don't know what it's called at every individual school. But it was basically like there was a moot court at the end of the you did appellate argument at the end of the course. And so everybody got paired up to kind of have one of these arguments. And I got paired up. I thought my argument went really well, and that, I was so excited to like have that done. And then your Aunt Jennifer, for some reason, it was either an odd number of people, or something happened with her partner, got sick or something, but she didn't have a partner. So they were like, "Hey, Jake, would you mind to kind of do Jennifer's argument with her, so that she can go ahead and we can have this kind of final part of the course done." I was like, "Sure, I've already done this once. Like, I'm fully prepared. Like, I kind of know what to expect." And so I went in there kind of confident, and she was so humble about it. Like, it was so humble about like it being her. I think she was kind of nervous, as you are with all kinds of law school. She kicked my butt. Like, I mean, it was like it was one of those things where there's been a couple of times in actual practice where I've had my butt kicked, but that was like one of the main times in law school where I came away and I was like, I thought I was ready, and I just got the floor. She wiped the floor with me. I mean, it was just
She
like
really is excellent. Yeah, I appreciate you saying that. But one thing you just said about that, you don't get your butt kicked unless you're out there actually trying cases. So
Yeah,
to me,
exactly.
I always talk about it all the time. I don't really care how much experience a lawyer has in terms of years. What I care about is that they're out there in the trenches, making creative arguments, winning the cases that all other lawyers indicate, you can't win this.
Yes.
And really stretching the judges and the prosecutors' minds and the arguments and the case law, and actually really developing wins that other people really can't attain because they're not down there in the trenches. They're not down there in the battlefield. Now, during the course of that, are you going to get your butt kicked a few times? Absolutely, right? But it definitely makes you better for the next time. And, I would say for you, Jake, as well, I can probably speak for you when I say in my 11 years of experience, I've got 30 years.
Yeah.
I mean, with all the trials and the jury trials that we've done, and unbelievable amount of motions to suppress. You'd be hard pressed to find lawyers, it doesn't matter our age, that are as experienced as we are. And so it's a pleasure to be on here with you as well, because your reputation is far and above what the other guys of our age are. So I really appreciate you having me.
Yeah, no, and I think that that's such a good point in terms of take cases to trial. There was an attorney, I can't remember who this was. It was at a CLE that I was at in Georgia a few years back, that basically said, you're not a real DWI lawyer until you've lost 10 in a row. And I think there's a lot of truth to that. Like, I mean, you really have to get used to just kind of getting beat up in the courtroom, having your argument denied. I think that can be frustrating, but at the same time, the Wayne Gretzky model of you miss 100% of the shots that you don't take, like that's got to be the attitude, because I think a lot of people are just so nervous about looking stupid in the courtroom that they won't try something different, unique, because it's kind of like people are going to think I'm ridiculous for that. Whereas that really doesn't happen very often. Even when you lose, most of the time, there's not really any question about the legitimacy of kind of giving your client the constitutional right that they deserve to have their case presented in front of the judge.
Sure. And also, if you're not making those efforts, now granted, you got to have something to hang your hat on. And just because a client calls you and you're a great lawyer, and you take their case, I mean, they may have nothing to argue. So it's not like we can sit here and say, yeah, every case is for trial, because it can't be that way. But the truth of the matter is only when you're in the trenches, only when you're losing that 10 in a row, that's when you're going to win the cases that you should not win. And that's when, you're going to have the dead bang guilty client. I've looked at a few of my clients probably in the past few years and said, look, I'm not trying to puff my wares, but if you'd have hired almost any other attorney, you would not have won this case. And it's just the truth. When you did a really, really excellent job.
Absolutely.
that maybe others could not have done. And there's a few of us. There's a number of other people in the state. Ron Shook, Chaz Post, a bunch of the other young guys that are really getting in the trenches and that are really good. And the first guy I saw do this was Bill Powers, and he's still out there kicking butt.
Yeah, he is.
He would
Yeah.
come to Rowan County, and I don't mean to get into war stories, but he would just try case after case. When I thought, oh man, that was an excellent argument.
Yes.
I don't think I saw him win a single case in Rowan County, but it didn't mean he wasn't doing an incredible job.
Yep.
He was. So
I totally agree. That was, he was definitely one of the heroes of kind of young practice. I mean, still is, but I mean, just it was like watching somebody kind of walk into the courtroom and just have this kind of commanding presence because of the fact that they had done it so many times. Like you can tell when somebody is kind of really not comfortable with their argument, even when they have, good argument to present, they just haven't really done it enough times to feel comfortable pushing the envelope. With Bill, nothing ever felt out of place, unprepared. It was very, very much, again, this teaching model of just kind of explaining, here's what the case law says, judge, this is where we are, this is kind of the history going. I mean, it was always that kind of very impressive control and command of the kind of legal precedent.
Oh, for sure. And, it's strange because there are good trial lawyers, and you can fit into both categories, but there are good trial lawyers, and then there are good DWI lawyers.
Right.
And of course, some good trial lawyers can also have the skill set to be good DWI lawyers. But some really good trial lawyers, you could stick an assault on a female, a robbery, anything like that in front of them. They're going to do a really excellent job. But unless you're really in the know in this super complex area, which is DWI, you can't necessarily fall into that same category. So, no, I'm pleased to be on here with you. I know we're talking about an incredibly boring topic in checkpoints, but I think hopefully we can walk through it in a simple enough way where, others can understand and maybe pick something up from this.
Yeah, exactly. Yeah. So we're going to focus on checkpoints just for listeners that are interested in learning more. Episode 15, we did a episode kind of about attacking checkpoints, which just covers some of the basic principles. So go listen to that episode. But today, James is on. He had recently done a CLE with the North Carolina Advocates for Justice on advanced strategies for challenging checking stations and roadblocks. So you can go to NCAJ and download or pay for that. You can do the kind of follow-up CLE or order the CLE and get a DVD copy so that you can see James's presentation and get all the notes from that particular CLE that James recently taught. But in terms of just kind of focusing on the kind of content and organizing it a little bit around kind of what you just recently presented, there was a number of things that were just like gold in terms of your presentation to me. And the thing that kind of right off the bat stuck out that I just never have done in a check station challenge was this kind of putting the burden onto the state. So just talk a little bit about kind of, what that looks like and how you kind of craft that argument when presenting a checking station case to the judge.
Sure, absolutely. I mean, number one, so part of the difficulty with winning these cases is you have to know your judge, right? And there's a couple of issues in the law which are excruciating to me as a defense lawyer. For example, and I'm going to bump into your question in a second, with horizontal gaze and nystagmus, it seems that depending on who your judge is, some judges will follow the law to a T just beautifully, as it should be. And then some judges, presume that horizontal gaze and nystagmus evidence, even though it's expert evidence, it's expert testimony, that it just comes in and they'll let me voir dire, but only for purposes of basically shifting the burden to me, not to prove that they're an expert and that the material is reliable and that it's reasonable. They'll essentially shift the burden to me in voir dire to show why it's not admissible, which is a total problem. Same thing with checkpoints. If you get a judge that's really inclined to follow the law, the first thing you have to remember is that the burden of proof falls on the state. We don't have to, as defense lawyers, prove the checkpoint to be not statutorily valid, or to be unconstitutional. All of that burden falls on the state. So I've won, and this is one of those in the trenches things. I've won a number of checkpoints where I have not asked a single question, not one.
That's wild. I mean, that's such a wild thing. When you said that on the CLE, I was just like, that's crazy. Yeah.
Well, you have to know, and of course, the first time you do it, you're like, okay, let's go for it.
Yeah.
But you have to know that they've got the burden. There's certain evidence that they have to submit, and so
I think that really makes a prosecutor's heart sink when the defense has an opportunity to cross-examine and they hear no questions. It's like, dang, I forgot something.
Yeah. Well, part of the, and I don't mean the new lawyer, I also mean the inexperienced lawyer in this area. This is why having an experienced lawyer is really important. Is part of the issue with, if you're not keen or up to speed on the burden of proof, part of the issue is if you're just asking questions to ask questions, as some people do, you can help prove sort of the prosecutor's case.
Yeah,
for them.
absolutely.
Fill in the gaps. And so it does take some chutzpah to not do that. But if you're confident in your analysis of the case law, if you're confident in your argument, and if you know that you can rely, you may have to go off script, but if you can rely on the fact that, Judge, here is where their burden is, and this is why they've failed to meet it, that's some of your best cases, frankly.
Yes.
So it's very important to remember at the outset of your hearing, really know the case law, really know what they have to present, and you don't have to say anything. Now you're going to have to make a darn good argument to prove why you didn't, but you do not have to disprove the constitutionality of the checkpoint. So make sure you keep the burden where it falls, which is on the prosecuting table.
Yeah, and in terms of just kind of putting that burden on the state, I think that one of just from a practical standpoint, and we are kind of educating judges, or at least we should be, as we're kind of presenting our arguments, right? Like that, to assume that a judge has an intricate understanding of every aspect of legal issues that goes through district court is just an impossible task. And so we're really not doing the court a favor or really doing justice in the courtroom unless we're being teachers of the law to the court in our argument. But I think one of the things that practically happens when the defense files a motion to suppress is just that kind of, this is the defense's motion, almost carries with it this idea that this is the defense's, burden of proof, right? This is the defense's requirement in terms of being able to push this forward, even where the burden of proof is pretty clearly on the state. And so I think that that's just always the best starting point, because anytime it's a defense motion, there's just this kind of, automatic, bias towards, okay, what is the defense going to show me during this hearing?
I 100% agree. Judges normally ascend to the bench, right? Normally, generally speaking, they've been very successful in practice. They've got a ton of experience, and they sort of ascend. They move up to the bench. Now, that's not always the case. There are some judges who are very good judges who not necessarily are great practitioners. But to think that just because you're a judge, you're an expert in everything. I mean, think about what you have to listen to as a district court judge. District court is volume court. It's right. The wild, wild west. You may be doing criminal court one week, and then the next week you're doing abuse and neglect court. And then the next week you're doing family law, either dealing with alimony or with custody situations. And so just to presume that the judge is an expert in everything that is in front of them is a horrible presumption to make as a litigator. So one of the first things that you need to do, we actually had a very fine judge, I won't name him, tell us one day when we were discussing a complicated issue in the back, he said, James, don't presume I know the law on every point.
Yes. Yep.
I'm not going to call that judge out, but he is a fine judge.
Yep. Just to
Slow
piggyback
down.
off on that for 1 second, I just, I had a judge that recently told me, I was going to present a case, and I kind of said, Judge, I know I presented this many times in the past, so, would you like me to approach with that? And he said, I want to read this case every time I hear this particular issue. I don't remember the cases. So again, just to kind of piggyback off that point, even if the issue has been argued in the past, again, I don't remember stuff from last week or last month. So, judges aren't superhuman people.
Yeah, definitely. And so the first, if you really are challenging a checkpoint, the first thing you probably want to do is just slow down, right? You need to let the judge digest the information, because there's a reason why they get me to teach on this topic at CLEs. It's excruciating case law to read. It's extraordinarily boring, and it's quite difficult to understand unless
Yes.
you really flesh it out. So the first thing you need to do is know not many people challenge checkpoints. Okay, so this is not something the judge is
Very
dealing
true.
with
Yeah.
on an everyday basis. Second of all, slow down. Give them an opportunity to listen to and digest what you're saying. The third thing you want to do is you want to point at the prosecuting table, and you want to say, as a reminder, Your Honor, and you want to quote the case law, the burden of state falls on that table, not mine. And this is what they have to prove to you. And so that's where you should start. It's not an equal playing field. It's not slanted towards the defense to disprove the statutory or constitutional basis for the checkpoint. That burden is on the state. So, as we discussed earlier, it's great to point that out. It's great to take it slow. Don't be afraid to go off script and say, oh man, they haven't, and we're going to talk about what they need to prove, but oh man, they haven't discussed what they need to prove, and don't ask a question. That's okay.
Yeah, no, I just think that kind of that methodical way of when you're kind of preparing for a checkpoint, kind of having a checkpoint argument, having this kind of flow chart of how to move through the argument, beginning with, slow down in big capital letters, but then, kind of specifically pointing over to the table. I think the prosecutors, I don't know if this is learned in like some sort of new DA school or what, they do a good job of pointing at people in the courtroom, right? They're very, they're really good at like kind of identifying the defendant and pointing at the table all the time. I think we could return the favor, point the
Sure.
finger, like it's important to, I think, have those visual cues for the judge, but really putting that in the, prosecution's, camp very early on, and then letting that sink in, like who's required to prove anything. That really is helpful in a case where you have the burden of proof on your side. And again, logistically, I've just not ever made that a part of my checkpoint argument, and certainly not the front end of my checkpoint argument. So definitely a new tool to kind of really argue in those cases. So, yeah, in terms of the, kind of written policies or plans that are required on a checkpoint case, you've had some success in really kind of challenging the form in which the checkpoint is disclosed, not having the appropriate paperwork. So talk just a little bit about kind of what that has looked like, and then, kind of maybe any practical examples of how that's played out in the courtroom.
Sure. Well, first off, again, it goes to your judge. It's much easier to make this point in superior court than it is in district court, I have found. But the rules of evidence still apply if you're challenging a checkpoint to the hearing. So Field Officer C should not be able to testify as it relates to what the supervisor told them and things like that. It's hearsay, at least not for its truth. That would be hearsay. Prosecutors, I guess, are taught to argue that the rules of evidence don't apply pre-trial. That's not true. They absolutely apply, except in certain considerations, which I didn't bring my evidence book, but I think it's Rule of Evidence 1101 talks about when the rules apply and when don't. It's always a phenomenal feather in your cap to make sure that you point out to the judge that the rules of evidence do apply during this hearing if you're challenging the checkpoint, because it's going to be very unlikely that the prosecution has every witness there to discuss the chain of command sort of as it relates to these documents. It's normally someone just basically unfamiliar with how it came about, but, oh, this is what our supervisor gave us.
That point is really important in terms of when do the rules of evidence apply. And I would expect, just because I feel like to some extent, DAs, a lot of judges, and probably a number of defense attorneys think that they don't apply in a checkpoint case. And there was, I can't remember, I definitely have heard you present on this issue before, but bringing that kind of case law and statutory law to bear in the courtroom, again, is part of educating the judge. Because again, I think that you very well might shock some people in the courtroom if you tell them that the rules of evidence apply on a checkpoint case.
Oh, for sure. But so that's the first thing you always have to be prepared to combat. And that's in really any sort of pretrial hearing. And where particularly I see judges get confused is they say, well, the rules of evidence very clearly say they don't apply in probable cause hearings. Right. Probable cause hearing is a term of art. That's a stage of a proceeding that is related to a felony case, right? It's not just any challenge of probable cause in any particular, area. When you're challenging probable cause as it relates to a DWI case, you're just challenging the sufficiency of the evidence. It's not this term of art felony probable cause hearing type deal. And if you go through the annotations in the evidence rules, you'll find some pretty good language that shows, the rules of evidence do apply. But back to your original question, you asked me about the forms. So statutorily, there's two forms in a checkpoint case that you should be looking for. Number one is just a general checkpoint policy. And what these are is just, let's say in my jurisdiction, you're dealing with the China Grove Police Department, okay? What a general checkpoint policy will be is just a general framework. It's usually a multi-page document, and it basically talks about how checkpoints should be conducted, how many officers are there, what they're supposed to do, and then why checkpoints should be conducted. And they usually say things like, you can do it for license and registration, you can do it for DWI, et cetera. But it's not talking about your client's checkpoint in general. It's just talking about a general framework. And the law is statutorily that in order for your client's checkpoint to be valid, that number one, the state must present evidence of a general checkpoint policy, this general framework that was in existence at the time your client was stopped by his checkpoint. Okay, so that's number one. The state has to prove, it's a burden on them, this general policy. Second of all, they also have to introduce checkpoint authorization, and that's specific to your client's checkpoint. Okay, so that's what, if it's legal, if it's valid, that's what should be signed and authorized by a supervisor.
Right.
That's what should be indicating the time the checkpoint starts, the time the checkpoint ends, the location of the checkpoint, for what purpose this checkpoint is, everything that's related specifically to your client's checkpoint. And not only do you always want to see that, but it's required that the state present that into evidence in order for the checkpoint related to your client be admissible. But not only do they have to present it, you also want to see it just in doing your due diligence as a matter of just, you asked for a war story or two. I've had a number of cases where I realized, oh my gosh, this checkpoint was authorized from midnight to 2 a.m. and my client was stopped at 2:16 a.m.
Yes.
Well, the reason why checkpoints are so as a DWI practitioner, you sort of become mini experts in like a particular area of law. One of the reasons I got into just really attacking checkpoints is I hate them. I am offended by checkpoints. Generally speaking, the Fourth Amendment requires some reasonable suspicion before you can be stopped, seized, pulled over, whatever. But checkpoints lack completely any individualized suspicion, right?
Yes.
They just throw them out there and they stop you. And I am extraordinarily offended by those. So that is a reason to check the general checkpoint policy. It's a reason to check the specific checkpoint authorization. You want to make sure that the state presents those both. If they do not present evidence on the both of them, then the case can, once the prosecution stops talking, the case can stop right there. Don't ask any questions. It's over. You win. And we have the authority for that listed in the materials on my website.
Yeah, exactly. And, I think that in terms of the, those specific issues of, what was allowed pursuant to that specific policy. I've seen a couple as well where the time frame of the stop is outside of the time. What they're supposed to ask for in terms of documentation is not kind of matching up with what they're asking for on scene. So again, looking to that specific plan, how many vehicles are going to be stopped, all of these kind of things. I think because so much of the time from a law enforcement perspective, if there's an agency kind of on it enough to even have a specific authorization, most of the time it's kind of like a fill in the blank form or a recycled form that has been used in the past. And so it's just easy to kind of get overly comfortable with how that's supposed to be working and then basically not actually execute the plan as it is written when putting it into practice on the roadway. So I definitely think you really cannot analyze a checkpoint case. So if your client stopped at a checkpoint, you cannot appropriately analyze whether you have a valid attack to that based on what your client is telling you, based on the initial consultation. You have to get those documents from the state in order to be able to assess if the checkpoint was constitutional.
You have to get those documents, and you also have to do the work and have a deep understanding of the law, because it is going to be very rare where it happens. This is why you have to know your stuff, but it's going to be very rare where they don't have those documents.
Right.
Or it's going to be very rare where your client is stopped outside of the authorization of those documents. And really what it comes down to during the course of the hearing, and this is why I get so frustrated, it's form over substance. And what I mean by that is, this is your ideal prosecution case is, Judge, we have put into evidence the checkpoint framework that was in existence at the time. We've put in the specific authorization for this checkpoint, which is signed by the supervisor, and we conducted the checkpoint during that time. All the I's are dotted,
right?
All the T's are crossed. I don't know why we're here.
Right.
The problem is, and I'm not going to take us too far. I'll wait till we dive into this. But most of these checkpoints are more out of convenience. They don't actually follow the substance of the law. They're all pretty much for general crime control with a box check that says they're for license and registration.
Yeah, that's so true. Yeah, that is true. I think that is, and again, even in terms of the recycled documents, you had brought up a point during your during the CLE about the proper primary programmatic purpose and what kind of satisfies that proper primary programmatic purpose. And one of the things that I've seen multiple times in even with our DWI task force in Asheville is, all Chapter 20 violations. And you kind of talk to that in terms of, I've said that that's general crime control, that's not specific enough to kind of meet a kind of narrowly tailored stop, kind of a narrowly tailored exception to the constitutional requirements to see somebody. So in terms of in terms of kind of going down that road a little bit, I know you talked about that in the training. So yeah, just kind of touch on that.
Sure. Well, as we're diving into that, sort of the framework for a valid constitutional checkpoint is first and foremost, and as lawyers, I don't know why we have to say this, but there has to be a proper primary programmatic purpose, right?
That actually would be a good like standardized field sobriety test. Just
can you say that?
Can you say that?
Yeah, I don't know. I barely did that sober. So first of all, there has to be this proper primary programmatic purpose, and I'm going to talk about what that is. And then second of all, if there is, then there has to be this balancing test that the judge undertakes to determine whether this checkpoint is reasonable or not, given the circumstances. There's 4 proper purposes for a checkpoint that are outlined by case law. The last 2 you're basically never going to see, at least here in North Carolina. Attempts to intercept illegal aliens.
Right.
Those are usually your checkpoints on the border. Right?
I think you actually probably could argue that if it was for that purpose, that it's not a legitimate purpose.
Sure, it'd be unreasonable, right? Right. But I've never seen that in North Carolina. You're probably not going to see that in North Carolina, but there have been some litigation from, your Mexico-U.S. border type checkpoints issues. So interception of illegal aliens could be a proper programmatic purpose. Attempts to uncover information about a recent crime, an unknown crime, an unknown perpetrator. So there's this recent crime. We don't know who committed it. We're trying to find out information. That's a proper purpose for a checkpoint, as opposed to just trying to uncover unknown crimes of a general sort. Right.
Yeah, the one that always comes to mind on my end is the shooter that was in DC a couple of years back, and they would do all of the checkpoints kind of exiting from that area to see if somebody's in a vehicle or whatnot. So that was, I don't think I've ever come across anything like that locally, but
no, I haven't in practice, but you can imagine, the hit and run with a death.
Yes, right.
Things like that. Yeah. And they're setting up the checkpoints to just try and uncover some information.
Right.
That makes sense. So those 2 are proper. A DWI is a proper purpose for having a checkpoint. And then lastly, license and registration is a proper purpose. Now, what your original question is, well, what about all Chapter 20 violations?
Right. I've seen that in multiple agencies' plans. And again, I don't know why they don't just put DWI checkpoint. Like, why wouldn't you just go off of like what is allowed? And then if you find other violations, then you find other violations. But yeah, you kind of spoke to that.
Sure. And there's not, in some dicta, there has been a discussion about that being a potential problem in North Carolina. And the reason is they don't want checkpoints to be used for the purpose of observing or for the purpose of finding readily observable criminal violations, right? So if you don't need a checkpoint to see it, then that's a problem if it's within the scope of the purpose of the checkpoint.
Right.
As opposed to where the checkpoint is being used to uncover unknown crimes, right? You can't look and see it's going on, like license and registration, right? Like DWI, assuming the guy's not driving all over the road, right? Like DWI, those kinds of things. But if they include readily observable violations, there is an argument under the case law that the purpose of this checkpoint is far too broad. It might include some things that are allowable, like license and registration, like DWI, but it's too broad for purposes of being a proper primary programmatic purpose.
Right.
And so that's, I think, what some DWI practitioners are currently arguing right now. I know I have one of these type cases in Rowan County Superior Court, and I'm sure there will be some case law on this in the near future in terms of whether that's appropriate or not.
Yeah, and I guess in terms of just some of those readily observable, things under Chapter 20, a tail light being out, tag light not being present, those kind of things would window tinting violations, whatever it might be. Those things would be, easily observable without having the checkpoint established, but they're kind of then still categorized under this catch-all. We're doing it for any Chapter 20 violation. So that's kind of is that the argument basically along that line?
It is. It's too broad. And what I think you have to appeal to, because there's not currently a specific case that says yes or no, I think what you have to appeal to is the rationale.
Right. Exactly.
We've got a case. I provided a case in the materials, which you can find on my website, that discusses, well, there may be some issues if the checkpoint includes readily available, criminal activity, readily observable criminal activity. But there's no particular case on point. But I think if you go back to the rationale, that we're using this for purposes of trying to evaluate what criminal behavior is taking place that's not readily observable, that would get you into a proper primary programmatic purpose. There may still be an issue. One of the things you just said is, I don't know why they don't just check the box license and registration every time.
Right.
Well, part of your problem then is if you get down to the next analysis and it's not appropriately tailored to license and registrations, then that could create the issue as well.
Right. So now you're able to ask about pretty much anything if it's all Chapter 20 violations.
That's right.
Well,
so anyway, just to go back and just hit those real fast, the four proper purposes: license and registration, DWI, interception of illegal aliens, and attempts to uncover information about a recent and unknown crime or unknown perpetrator. Those are the four proper purposes. I'm pushing the DWI practitioners to say that a checkpoint for all Chapter 20 violations is too broad. And there is specifically, as of now, no authorization for that at this point.
I encourage anybody that's got something like that going on to really push that issue, because I think that, if you have a case where it says something along that all Chapter 20 violations, or even, lists out a laundry list of them that aren't kind of specifically allowed under the, kind of framework that James just laid out, these specific things, really DWI and license and registration, this seems to be kind of a exclusive list, right? Like there's a reason why we have specific cases on these particular issues.
Yeah, and if you go back to the burden of proof, it's right where we started. The burden of proof is on the state, right? The only thing that says a checkpoint is allowable for all Chapter 20 violations is this form that law enforcement officer checked.
Yeah, that's great. Yeah.
Can the state show one case that says all Chapter 20 violations are okay, which it's their burden? None, not
right.
one.
Right.
Heck, Judge, I can show you license, registration, DWI, and these other things, but all Chapter 20 violations, that doesn't fly. You're extending the law.
Yeah, I love that. I love tying that back into the burden of proof, because again, it's kind of like they've got to show you why this is the maybe we can't use the PPP terminology because now its meaning is skewed somewhere else, but that proper primary programmatic purpose, they've got to be able to show that. That's their burden to have to kind of show that this is legitimate, that it's got a kind of legal framework for pushing that. So tying everything back into that burden of proof, like they've got to show this, Judge. Like it's not about me to show this is a proper purpose, that the checkpoint was done reasonably. They've got to push it back. I love that.
Yep.
So yeah, I guess kind of moving then on into the second part of the analysis, assuming that there is a proper purpose, what do we then do in terms of kind of the constitutionality and really kind of it's the second and third kind of prongs under Rose that really bring out kind of most of the ability on the defense end to kind of challenge the reasonableness. I've not really had much success under the first prong, but yeah, just kind of, what is some of those factors under Rose that are considered, as well as kind of, some of the questions or issues that you look for in a checkpoint case.
Sure. Well, just remember, with regard to the proper primary programmatic purpose, that first of all, it's the supervisor's purpose, right? So if the state only has a field officer testifying, the case law is very clear. They don't care as it relates to what the field officer's testimony is. And where you might get that is where a field officer, non-supervisor, they're working the checkpoint, is the one who intercepts your client. He's the one who charges your client. He's
right.
The only officer there for purposes of the hearing. So with regard to that, they're looking for the supervisor's purpose only. And the court can't presume from a silent record that constitutional requirements have been met. So again, if you're not hearing from the supervisor, or if they're not appropriately entering evidence from the supervisor, it's not your problem, it's the state's problem. One more thing about proper primary programmatic purpose, and then I'll move on. The court has to conduct a close review of that scheme at issue.
Yes.
So the reason why that's important is, if they're saying it's a license and registration checkpoint, the officer's testifying to that, all the documents say that. If the court's going to closely review the scheme at issue, well, they're going to want to know who the participants are, for example. So I would have to ask you, is it really a license and registration checkpoint if there's 5 officers conducting it? All of them are narcotics officers, and all of them are using drug dogs to walk them around the car.
Yes. Yeah.
Right? It has no rational relationship
right.
to be for license and registrations.
And then how many citations were issued for license and registration at that particular checkpoint as well?
That's right. And when you see the license and registration checkpoints at 2:30 a.m. on a country road, right? Like, how likely is that? So those are just some additional things you want to look for with, it's a close review, is it a proper primary programmatic purpose? And then you really have to dive into, really the question that you're asking there is this really that kind of checkpoint?
Yes.
Okay. And I'm not saying it's not. I'm not saying it is. Is it really that kind of checkpoint? And so you're going to learn that from, the location, the officers involved, how they were actually conducting the checkpoint, that sort of thing. Now,
just to jump in on that point real quick, from a practical standpoint, I think that is a good reason to ask to sequester witnesses on a checkpoint case, between supervisor and people on the ground, because if the field officer says, well, this was a DWI checkpoint, and the supervisor says this is a license and registration checkpoint, clearly the programmatic purpose has not been communicated very well. It's basically just, again, form over substance situation. So, that I've definitely seen that kind of miscommunication going on where and again, I don't know why officers never talk with each other before trial, but they apparently don't seem to communicate real well about what's about to happen in the courtroom. So anytime that you can sequester witnesses generally is a good idea, but I would say specifically on checkpoint cases, because there is typically such miscommunication between supervisor and the officers in the field.
For sure. And even if they know, that's a great point. And even if they know, hey, it's a license and registration checkpoint, right? Even if they know that, it's hilarious to hear their answers on, well, when did you meet with the officers who were conducting this checkpoint? What information was relayed to them? How was it relayed to them? What specifically did you talk about? Who all was present? They never remember those things. And maybe it's because they didn't have that communication. or maybe they did and they just forgot. I have no idea. But it's important because even if the supervising officer says that it's license and registration, and even if the field officer has the wherewithal to say that it's license and registration, how was it communicated to you? What the purpose was, how you're supposed to conduct it, all of those things. So that's important. Now, just because, getting back to your original question, just because if it is a proper programmatic purpose, let's say like they really are conducting it as a license and registration checkpoint or as a DWI checkpoint, that doesn't necessarily make it a constitutionally reasonable checkpoint. In fact, I think the language is it's not even presumptively constitutional, right? It's just a balancing test to determine whether it's reasonable or not. Now, the first factor when they're trying to determine whether it's appropriate is how important is this checkpoint to the public's interest? And you're not really going to get any traction on that one, because if it really is this proper purpose, then the courts have already determined, well, that's an important thing that we want them to be able to check for. The second factor is the degree to which the seizure advances the public interest. This is where you're going to win your case, okay? You're either going to win your case on, when you're doing this close review, that it's not what they say it is, right? It's really not a proper programmatic purpose. That's when you have your 5 narcotics officers doing general crime control, but they check the box that it's license and registration, right? So you're going to win on that issue, or you're going to win on this other issue, which is that it doesn't advance the public interest. And there are 4 factors that go into that. Whether the police spontaneously decided to set up the checkpoint on a whim,
which happens a lot. So that's
my gosh.
So,
yeah, totally.
We don't have anything going on. We want to throw a checkpoint up. And it's funny how often that's like actually not contested. It's just like, yeah, we just didn't really have anything else going on. So we called the supervisor and asked if we could put a checkpoint up. It's like, well, that seems
sure.
Okay.
Yeah, that's normally, so normally they're actually put up for convenience purposes. That's what I've found.
Yeah.
They've either got a lot of officers working or it's a slow night. Let's pop one up, and we get the supervisor approval. The second factor is why a particular stretch of road was chosen for the checkpoint. The third is whether it had a predetermined starting or ending time. And then fourth is why that particular time span was selected. This is why you have the factors. Here's all they're trying to say. If you're setting it up, I'm going to say DWI, okay? If you're setting it up for DWI, and we need the supervisor to determine what location, what time period, and why we're having it at this location, okay? How effective is it at addressing that purpose?
Right.
That's the whole thing. And here's the beautiful language from State v. Rose. It's got to be, they call it tailored, how tailored it is to the purpose. Another way of just thinking about it is how effective is it in addressing that purpose? And Rose says, without tailoring, it is possible that a roadblock purportedly established to check licenses would be located or conducted in a way to facilitate the detection of crimes unrelated to licensing. So the point is, I don't think you're ever going to find a judge who's going to say, these officers conducted this in bad faith. Right. So what you want to argue is, they have shown this is set up on a whim, random location. It's purely out of convenience. Their own testimony shows that it's located not in a way, thoughtful way to address DWI, thoughtful way to address license and registration. Their own testimony has said, it's just located in a place that out of convenience, which sounds like we're going to find what we're going to find.
Right. Exactly.
Right?
Yes.
It's not tailored at all. So, and that's the two issues that you really come to if the checkpoint is invalid. It's one of those two things. It's either not what they say it's for, or it's what they say it's for, but it's not effective at all in addressing the problem that they're trying to address. And again,
I love how you've brought this out in terms of kind of, you got a couple of officers that are on a country road at 2:00 in the morning doing a license and registration checkpoint, not heavily trafficked at this hour of the day, not likely to bring many people through this particular location. Why are we choosing to do it now versus at this same location at noon or at a, much more heavily trafficked area of town, during the same time frame?
Look, I hate to say it, but checkpoint after a Panthers game,
Yeah.
DWI, probably going to be appropriate.
Yeah,
right?
Exactly.
Checkpoint after the Luke Bryan concert, probably going to be appropriate, right? But just to randomly have it out there in your country road at 2:30 a.m. because you're bored, that's not effective at addressing what they're trying to address.
Right.
And the very first thing that you talked about, Jake, if you're pointing it to that burden of proof, right, they've got to show you that this is tailored to that issue. They've got to show you that it's going to be effective in addressing that issue. They haven't even presented evidence that they stopped one person or two people that this is supposed to, get to. And they haven't talked about what issues they've had previously in that area. They haven't talked about, hey, we had 15 DWIs in this area, in the last week, and we're like, oh man, this is a really bad area, so we need to check on this because apparently there's drunk drivers out here a lot. That's again this form over substance thing. They're going to have the forms, assuming they're prepared, but the substance, the rationale, just isn't there.
Yeah, I just thought of a good question that hopefully spur of the moment won't come across in the as a idiotic thought on my end, but I think a good question for any license and checkpoint case might be how many citations did you issue for not having a license on this particular date. But then also outside of checkpoint situations, how many no operator's license charges have you issued in the past 3 months, 4 months, right? Because I think anybody that's working that night shift and is kind of pulling people over to kind of more investigate driving while impaired than anything else, you're speeding 15 over, you're not getting a ticket for speeding 15 over. You're driving around with no headlights on, and then you pull out of a gas station, no headlights on, you're stopped by an officer. Maybe the officer's a real jerk and they issue you with the no headlights, but likely it's just like, I'm stopping to see what's going on. So I think that might also kind of go towards that factor of, is this really even a concern on law enforcement's end in terms of the license and registration piece of things. So I don't know.
Yeah. And you have to be very fluid in how you're going to attack this, because really you have no idea how the evidence is going to come out.
Right.
I have found, certainly I want to see the documents beforehand, but generally speaking, if I'm going to challenge the checkpoint, I'm not asking the officers a lot of questions beforehand.
Right.
Now, why? As an experienced practitioner who learns from his mistakes, you realize in your first year of challenging these things, man, the more questions I ask them to determine if I've got a good claim or not, the more I'm preparing them.
Right.
Right.
Yeah, totally agree.
So you've got to be really fluid in terms of how the actual trial is going to go.
Just to that point real quick, in terms of looking at the documents, again, 9 times out of 10, the documents are in and of themselves going to establish a legitimate checkpoint. So it's really through testimony that you kind of undermine that validity. And I think that it's so easy, especially as a young new attorney, to get like a DWIR back from the officer or from the state, and you look at it and you say, well, my guy's dead to rights. They're seeing 4 out of 6 on the HGN, 3 out of 8 on the walk and turn. It says that my client is like swaying, on their feet. And then all of a sudden you get the video back, or you actually start asking questions during trial, and you're like, this officer has no idea what they were doing in terms of field sobriety tests. And you're not getting that from the report. You're getting that just from what's coming out on the stand. So just recently I had a case where a judge granted a PC argument. And it was really because the officer just had no business doing HGN, really didn't understand what clues that she was looking for on the walk and turn and the one leg stand. And on the DWIR, my client was impaired dead to rights. Like there was nothing in there that would have said this is a good case to take to trial. But having watched the video and seeing kind of lack of experience there, and then kind of bringing that further out in testimony, it was like, this officer had no business arresting this person.
Yeah. And that's the next step. Our job, I don't want to say it's getting easier, because some days I think it's easier and some days I think it's much harder. But one thing that I have found that seems to make our job a little easier than it was 10 years ago is the use of body cameras. Every officer who arrests your client for DWI, I would challenge any lawyer to just please email me, call me, send me a text. If you've ever had an officer charge someone with DWI and then get on the stand and say, no, I didn't think they were impaired.
Right.
That will never happen. Of course, they're going to attempt to justify their opinion. They're going to attempt to justify their behavior. The best thing that's ever happened for me in terms of PC motions and otherwise are those body camera videos, because you can show, some officers can beautifully recite the 3 pages of the field sobriety testing manual on how to conduct an HGN test. But when you see them actually administer the test on the body worn camera, it shows that, well, they might can tell us how to do it. They might can testify how to do it. They might can say they did it this way, but they didn't.
Right.
And what I am most looking forward to are taking it back to this, when we don't have, not all of our law enforcement entities in Rowan County have body cameras. And so most of my checkpoints don't come with body cameras.
Right.
I am going to be thrilled for the day, and this is the next sort of step in the analysis for the defense lawyer, when you can actually see, it's just what Jake said, instead of doing it for field sobriety tests, you do it for the checkpoint.
Right.
And what you're trying to determine is, your license and registration checkpoint. Are they actually administering this as a license and registration checkpoint setting? So I want to say, maybe I should say, as a fact finder with body worn cameras, the job is becoming easier as those become more readily available, because you can really look at, hey, does this person look drunk? You can really look at, hey, A, did they administer the field sobriety test correctly? And then B, did your client actually fail it? You can look at how they conducted the checkpoint, those types of things. So I'm really looking forward to that, because absent those cameras, it's tough to trip people up on certain aspects, maybe in HGN, maybe in how they perform field sobriety tests. But as it relates to checkpoints, no, I just check for their license and registration and let them go. When it wasn't conducted that way, that's a little different.
Exactly. Yeah, definitely. I'm sorry I derailed us from the reasonableness there, but I think that in terms of that second Rose factor, I don't know if you had anything else that you kind of wanted to add to that before moving on to the third Rose factor.
No, and I would actually ask you. So there's a number of factors for the third factor. I have not had the third factor in any case be determinative. The factors are basically, they appear to sort of mimic the statute 20-16.3a, which are, hey, what's the checkpoint's interference with legitimate traffic, whether police took steps to put drivers on notice of an approaching checkpoint, whether the location was selected by a supervisor rather than officers in the field, whether police stopped every vehicle or stopped vehicles pursuant to a set pattern, whether drivers could see visible signs of the officer's authority, whether police operated pursuant to any oral or written guidelines. You see, this third factor sort of just mimics a lot of the other stuff that already has to be proved by the state. So on my end, I would love to hear in your experience, if there's any, Jake. I've really only had success in, is it a proper purpose? And is it really that thing? And then alternatively, is it effective at actually addressing that? Yeah, and those two areas are all that I've had success in.
Yeah, the third one I think is helpful in terms of giving like a specific cross-examination checklist. So in terms of assessing reasonableness, right? It's not as though if the state gets 2 out of the 3 factors, then they basically have carried their burden. Or if the defense has 2 out of the 3 factors, then they've carried their burden. It's one of these terrible balancing tests that basically gives the judge whatever room they want to have to make an argument. So, I've really kind of looked at the factors under prong 2 and prong 3 as basically just being kind of this collective analysis, as opposed to kind of so much bifurcating those two specifically. So for factor 3, one of the things that I've tried to do is really just kind of make that my cross-examination list. And then when these things aren't being met, then to just kind of reiterate that to the court. Like, this is a specific factor that was important for the state to show that they have a reasonable checkpoint, and they didn't meet that. So the factors under 3 are just kind of slightly more specific than the factors under 2. And so again, just kind of trying to really like lock in the officer about these particular, steps that you just went through. And
I agree with that, but I think I'm glad we're having this conversation. I think you really, in my opinion, what you do is you really dive into those factors if they were brought up by the state.
Right.
But if for some reason they weren't brought up by the state, then this is sort of your multi-factor checkpoint to say, yes, hey, judge, they had the burden to show you this. They didn't address this. How can we say this is reasonable when every single factor is wholly absent?
That's a great point. I think that that being kind of the place for silence. Yeah, I will agree with you, 100% on that. Basically, these factors were specifically laid out by the court. State's aware of these factors having to be met in order to carry their burden. And here's all the things that they didn't talk about. They didn't talk about this factor, this factor, this factor. So yeah, I mean, I think if you're getting in their own testimony, whether or not those things occurred, that may be the better approach. I've definitely done a cross-examination on that front to try to kind of show specifically that the state didn't meet these factors. But again, my psychology may change a little bit on that to where, kind of following your outline, let's leave the burden on the state. The state has the burden. This is not in any way, shape, or form supposed to be our burden to carry. We don't have to show anything. So yeah, I would definitely say that that's the right approach to it.
Sure. And I think it's art, not science, right?
Right.
As you're going through it, if you think your argument's going to sound better just by leaving that alone and saying, this is very important to the court, all of which they didn't address, walk through them one by one, then I think that's a great way to do it. Alternatively, if you think the judge wants you to hammer on those points, then try and hammer them. I think it's more art. It's it's learned in the trenches and whatever you feel is most appropriate, then I think either way has a good justification.
Yeah, totally agree. I think one thing that I don't think we had talked about, but again, this was just one of those gold nuggets that stuck out during your presentation in terms of, and I don't remember if you mentioned this under the second or the third factor, but one of the questions that you had in your kind of like model cross-examination was how many officers at a DWI checkpoint are actually specifically trained in investigating DWI cases. And that was like one, one of the attorneys at the office that was watching with me, we were both like, that's a gold question right there, because there's so many times when I've had a checkpoint and they've literally like had to call another officer to the checkpoint. And it was a license and registration, but it's just like, you really should have somebody at these kind of checkpoints that's trained in this. So I just love that question.
Sure. Well, I actually want you to use that not for the secondary analysis, but for the first analysis.
Okay, gotcha.
Because if it's listed as a DWI checkpoint, again, we're trying to determine, is this really what it is, and is this really what it's for? So you're right. When I was walking through, is it a proper primary programmatic purpose on your show, what I talked about was the license and registration checkpoint where it's all narcotics officers, right? It's not really for that if you're conducting
exactly.
Let's review the scheme at issue. Same for the DWI checkpoint. If you've got a DWI checkpoint and the officers aren't proficient in investigating DWI, what are they doing then?
Right.
It's the crime control thing, right?
Yeah, that's great. I really think that that's such a valuable tool, because there's just so many times when, there's 15 officers at a checkpoint and somebody stops, and then they've got one or two officers that are even able to do any type of like, real analysis. And these are like DWI task force run checkpoints in Buncombe County. And so they'll pull in, one of the officers that actually can investigate it. And it's kind of like, why is everybody not, able to do their own standardized field sobriety test? Now that you have to bring like the stopping office, like literally the officer that's like, park your car over here, as well as the, specially trained DWI task force officer to come in. It just, doesn't seem like a very efficient, methodology, but I love bringing that into the actual checkpoint argument.
Do you have, just to get us completely off topic, is it common where you have law enforcement officers stop someone, think it's DWI, and then they just hold them there
a lot
for minutes and or hours to get somebody there to investigate?
Yeah, that happens very frequently. There's, I would say, especially with the Buncombe County Sheriff's Office, they do that pretty frequently. They'll hold until one of the DWI task force officers come out. And we had a case about a year ago that was dismissed kind of primarily on Rodriguez issues. Basically, there's no reasonable suspicion, right? Like you basically just have an odor of alcohol. Somebody's stopped for speeding, plenty of time to issue the citation for speeding, no additional evidence of impairment. At some point, that first investigation related to speeding ends, and then you either have to have additional, reasonable suspicion to believe that person is impaired, or you have to kind of conclude the investigation. But there's been a ton of cases recently where my client's sitting at the roadside 30, 45 minutes waiting for another officer to come in, and basically because of a PBT or an odor of alcohol, they're just sitting in their car waiting for the second officer to show up.
Okay. That should be your next podcast episode for sure.
Yeah. I mean, that's gotta be, are you seeing that a lot down your direction as well?
Not often. I've got a case next Friday.
Okay.
Where I'm arguing that particular issue.
Yeah. To me, this is much more, intentional in terms of this being how to actually kind of investigate DWI. It's not like this just is kind of like random thing. It's the stopping officers are kind of being told, hey, you stop somebody, odor of alcohol, or you believe is impaired, call one of the task force officers. So it's not, again, it's just going to continue because that's kind of the practice for how to, resolve these kind of investigations.
Okay.
But yeah, no, James, I think that's probably a good place to wrap. If we have, any listeners that have made it an hour and a half into checkpoint analysis, then, I'm going to send you a gold star in the mail if you've completed the hour and a half training. But no, in all seriousness, it's been really powerful. I think checkpoint cases aren't challenged enough. And I think part of that is just a lack of understanding of what can be challenged, what evidence looks like, how you kind of do this, not really seeing these things litigated sometimes in the courtroom, and just, again, looking to other attorneys to challenge these things. So again, if anybody has a checkpoint case that they want to bounce off of attorney, call James and ask him, hey, what do you think about this particular case? Call me, talk to somebody in your local bar, bounce these ideas off of somebody, because you can get some great direction in terms of how to challenge these things. And we're happy to help. I mean, it's not something that is a burden. We want to see these strategies actually implemented in the courtroom.
Yeah, I've always heard there's a lot of competition between lawyers, but it's not that way for me, and at least in a small town. I like to see everyone succeed. I like to see everyone learn. I like to see everyone grow. And I'm thrilled that you asked me to do this, Jake, because it's my hope that maybe 10 lawyers that listen to this will say, hey, I'm going to take that next step. I think I've got a decent enough understanding on how to do this that I'm going to get after this for my client. And I think at the end of the day, where lawyers become, especially aggressive lawyers, where we become frustrated is we don't see. It's funny because law enforcement is tasked with, ensuring citizens follow the law. But we also are that check and balance. We want to make sure they are following the law in terms of the courtroom. So I think as an attorney, where I get most frustrated is I want to see law enforcement follow the law as well. And I don't think they're doing it, at least as it relates to checkpoint, intentionally wrong. But it is a very complicated area of the law. And I just don't want more and more innocent citizens to get stopped by virtue of because some forms are checked, right?
Yes.
I just give me a reason not to challenge the checkpoint, right?
Right.
I won't challenge it if you've done everything correctly. If you're right out there right after the Luke Bryan concert, I don't have much to talk about.
Right.
But, that's the main thing for me. And, if we're not fighting, then our clients' rights aren't being stood up for.
Absolutely.
We just want to hold everybody to following the law, and I think that's very important. And I hope our brothers and sisters continue to do that. And I appreciate you and your podcast for putting all this information out there for people.
Yeah, no, definitely, James. I'd echo that. I think, and you probably had this experience too. I can't tell you how many officers after, a case will come up to me afterwards and be like, thank you. I didn't, this is kind of eye-opening. I'm going to go back and kind of, look at this issue a little bit more closely, or kind of go back and kind of review my training. The goal is not to put more impaired drivers on the roadway. The goal is to kind of, hold law enforcement's feet to the fire so that they can prove crimes that are being committed in North Carolina. And that's part of what we are doing. That's part of our profession. So I definitely echo that. It has been, amazing having you on the podcast. Definitely don't think it will be the last time. I know you've got lots of other areas of expertise to kind of share with the audience. So I look forward to the next conversation.
Sure. Well, let's monitor the bad reviews on this one first before you call me again.
That's right. Sounds good, James. I appreciate it.
Take care. Thanks so much, Jake.
Take care. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.